Hello and welcome to interest.co.nz. I'm Gareth Vaughan with another of our double shot interviews, and I'm here at Chapman Tripp with Arthur Young, who's a senior partner here. Thanks for making some time for us, Arthur. We're here to talk about proposed changes to trust laws. The Law Commission is recommending the introduction of a new Trusts Act, which would replace the 1956 Trustee Act, and it says that this new proposal would be a new Trusts Act fit for the 21st century. Now, Arthur, this report contains 51 recommendations recommending wide-ranging changes relating to, I guess, the roles of the various parties involved in trusts and the powers of the courts. One thing I'm interested in, I guess, to start with, is to what extent do you think this proposed revamp of New Zealand's trust laws, which are well known internationally, is being driven by the recent introduction of our anti-money laundering laws and international pressures coming through that way, and the US FATCA laws, and I guess this general push by national tax authorities to track down more of their country's tax following the global financial crisis, because our trusts, obviously, they're well known and utilised by foreigners as well as New Zealanders.
I don't believe that the international pressures, and those originating from the OECD and elsewhere, are actually a feature of the Law Commission's thinking. We've made submissions to the Law Commission right throughout on all its introductory papers, and these kinds of international fiscal considerations hadn't ever featured in any of their commentary. So I think it's coincidental. It is an important consequence, though, that if the new law comes in, it will apply equally to New Zealand foreign trusts, which, as we all know, are a special animal here because New Zealand happens to be a favourable jurisdiction for a series of unrelated technical reasons. I think it's a coincidence.
Okay, obviously there are lots of New Zealanders who have trusts. I think the Law Commission says between 300,000 and 500,000 trusts out there, so a lot of us have them. If I'm a beneficiary of a trust, what will be the main changes that I'll notice if this proposed law change goes through?
I think three significant changes. First, the law will be more accessible. At the moment, the law can be found only in complicated textbooks or a very archaic and extremely narrow statute, the 1956 Trustee Act. So, firstly, the law will be more accessible. Secondly, beneficiaries will be recognised more clearly in the legislation than in anything in the past. They will have, within limits, entitlements to information as to their position as beneficiary and the assets and circumstances of the trust. There are limits around that, but that's an entitlement. And secondly, they'll have more ready access to the court to challenge decisions by trustees. They'll need to put forward a prima facie case and show that there is a substantial, not trivial issue, but then the court will have a wider jurisdiction and I think a greater willingness to weigh in and just assess the issues between the beneficiaries and the trustees.
One noticeable point the Law Commission's made is around relationship breakups. There are going to be some changes around how the trust is operated, utilised in that sort of situation. What's the key difference there? The
key difference is actually can be significant monetarily, but it's relatively narrow in legal terms. At the moment, under the existing legislation, if the court, and it's often the family court, the relationship court, feels that an asset has been dealt with to the disadvantage of one of the relationship parties, then the court can order an income share to pass to the person deprived. That will be widened, and it can be not only an income share but also a capital interest or a capital sum of money. So that would be one significant step.
And in terms of trustees, are they proposing some changes for the duties of trustees?
Yes, there are significant changes. or probably it's more correct to say they're clarifications. There'd be two categories of duties. There are mandatory duties which will always apply to every trust, whether it's an existing trust, a New Zealand trust, an overseas trust, or a newly established trust. And they're the sorts of things that really go without saying, that you'd expect always to feature in a trust, like the duty to act honestly and in good faith, and to act for the benefit of beneficiaries. There are then a series of default duties which are presumed to be applicable, although they can be varied by the trust document itself. And we'll find in practice that lots of those do become varied. So there's this distinction between mandatory duties and default duties which are capable of variation.
And what about the appointment of trustees? Is that going to change? And also, if beneficiaries want to remove trustees, is that going to be easier or more difficult?
Essentially, there's no fundamental change regarding the appointment of trustees. So whatever the trust documents provide will carry and continue to carry the day. There are a couple of new provisions. If a trustee becomes incapacitated, say bad health, then there's a requirement that the person who has the power to appoint the trustee must make the change. And there are one or two other provisions which will, I think, probably serve to widen the arena that the court might contend with if there are issues regarding whether trustees are acting or whether they are just passive and not acting at all. Some, I think, widening of the opportunity for court intervention, but no fundamental change.
Yeah, that was going to be my next question, was whether the courts would get new powers or broader powers or even restrained powers under these proposals. I mean, what's the overall thrust of what they're proposing on that front?
The overall thrust, I think, is to elevate the focus on beneficiaries. I think a new balance is likely to emerge between the interface between the beneficiaries' interests and the trustees' roles. We will have, whilst there's no fundamental change, I think a clearer framework, and because the framework is clearer and the law will be more accessible, I think we can expect a higher level of focus on the parts of beneficiaries and probably an increase in recourse to the courts or the legal avenues that the statute opens.
Just one very sort of tabloid journalist-esque type question here, if I may. Often, I guess, there's a sort of view in some quarters that people can use trusts to hide assets. So if someone wants to sue them, they can, I guess, maintain that they don't own those various assets. Are these law changes going to change things on that front at all? I mean, is it going to be easier to trace what people actually really own?
I don't think that's a focus of the legislation. I think the focus of the legislation is more to achieve a regime where beneficiaries have a clearer standing, greater access to process and really intervention from time to time on the part of the law. Will trust busting, so-called, via relationship arguments then increase? Perhaps, but not greatly. Will it be easier for people to attack trusts than they have been able to in the past where there's been business failure and insolvency? Not obviously. I don't think there's any real change in that area.
And they're looking to extend, I guess, the life term of trusts for up to 150 years from, I think it's 80 at the moment. Why are they looking at doing that?
Well, this is a worldwide debate as to the legitimate or sensible duration for trusts. We had previously archaic rules, which then were revised some years ago, and 80 years was brought in as a simplification. Some jurisdictions abroad have no time limit on new trusts. I think the 150 years is a compromise. I think it's a sensible compromise, and it's one that I support. 80 years when there can be genuine long-term intergenerational considerations within an asset-owning family. We can think of farms here in New Zealand which have been in the hands of a family for a very long time. I think 150 years is an appropriate time. 80 years is too short.
So these are proposals from the Law Commission, so what happens next?
My understanding is that in government and the Cabinet Office, there'll be a review of the Law Commission's recommendations. There's to be a response by the government by 31st of March of next year. Hopefully that response will be positive. Hopefully then a new statute or new bill will be formulated and will come before Parliament. I think there are serious questions as to whether there will be legislative time next year for this to go the full distance, but as a trust practitioner, I'd be very keen to see the Law Commission's good work brought through to conclusion, and hopefully in the lifetime of this Parliament.
Well, thanks a lot for that, Arthur. That's Arthur Young, who's a senior partner at Chapman, Tripp, and I'm Gareth Vaughan at interest.co.nz.
Thank you, Gareth.